Now we'll discuss the definition of tort. And before discussing the definition of tort, we shall discuss about its uniformity and universality. There is no uniform and universal definition of tort, and it is due to some vital reasons. These are: firstly, the law of tort is still growing, as because, like an apparel, it is changing and growing with time, so to fit it accordingly with growing complexity by creation of new torts. Secondly, judges, while deciding cases, do not lay down under rules or wider rules, and they never manufacture any definition of it in legal form. Lastly, procedure and writ for any remedy had substantially played an important role for a long period in England. So there was no uniform definition of law of tort. In spite of the above reasons, some jurists and scholars attempted the definition of tort. Among them, Salmon, the English jurist and professor, defines tort as a civil wrong for which the remedy is an action for unliquidated damages, which is not exclusively the breach of a contract or the breach of a trust or the breach of other merely equitable obligations. This definition expresses the presence of three necessary elements. One is every tort is a civil wrong, and that means compensation for the injury suffered by the person in a civil court, which is quite different from criminal wrong, as because the criminal wrong is only could be filed in a criminal court and it can be initiated by the state. The purpose is to punishing the person who had committed the crime. The second element is the breach of contract, breach of trust, and breach of equitable remedies are also civil wrongs, but they differ from tort, as because while the farmers are between specific parties, but tort is against any person, world at large. And the third element or condition is that it is an action for unliquidated damages, which means it is not prefixed. The quantum of damages responds on the discretion of the court. So Salman's definition of tort constituted mainly three basic conditions or elements. According to him, it is a civil wrong, and that civil wrong could only be initiated in a civil court, and where it would only for unliquidated damages. And when it is unliquidated damages, there is no fixed amount of damages would be awarded by a civil court of law. So also, this civil wrong or tort is different from breach of contract or breach of trust or breach of any equitable remedies. And it means that in breach of contract or in trust or in case of equitable remedies, there are specific parties, and the specific parties, they reached an agreement or contract for a specific purpose, so the damages are prefixed. So this is how a tort differs from contract, trust or quasi-contract, etc.